think Chairman Petrarca, you had some remarks you want to share as well?
Thank you, Todd. Yeah, I too would like to welcome everyone here. Certainly appreciate our testifiers spending the time to be here this morning with us. As we proceed, though, I guess I just had a few comments and thoughts. When we passed this resolution in committee and then before the full House, I guess things have changed since that time. Obviously, with General Kane deciding not to seek re-election to the Office of Attorney General, and I wonder what that means or what that should mean to us as we proceed. We certainly, I think Chairman Marsico and I have a lot of confidence in the Subcommittee on Courts and the gentlemen here and the gentlemen and ladies on the committee that this process will be done in a fair and bipartisan way. However, I still do have concerns, and maybe heightened concerns now, that regarding the timing of this case or this inquiry. We have an Attorney General that has a finite or specific time in office at this point. My recollection of the Rolf Larsen impeachment in 1994, although I was not a part of that, I had clerked for Justice Larsen while in law school in the mid-'80s, so I certainly followed those proceedings and that investigation, and it seemed to me that it was a very tedious, long, and drawn-out process, and I wonder, again, it gives me concern related to the time that General Kane will be in office. I also am cognizant of the fact that there is a criminal case and investigation underway that has a date certain later this summer, and I worry about this the proceedings before this subcommittee and our investigation into General Kane's conduct and how it will affect that criminal case as that proceeds. Last question that I have, or the last comment that I would like to make, is regarding the cost of this. I think that, again, if you look back at what happened with the Larsen investigation and the amount of time and work that went into that, I think it was a tremendous amount of money that was spent by the Commonwealth, and I worry about how that should be viewed by us, again, with everything that I had said and with the state of financial affairs in Pennsylvania. So with that said, again, appreciate everyone being here and look forward to the testimony. Thank you, Todd. Chairman.
Sure. Thank you, Chairman Petrarca. And, you know, just for the information of the members, we have Representative Briggs and I, along with Chairman Marsico and Chairman Petrarca, have been meeting just to sort of lay out some of the procedures and some of the background work that might need to be done in this regard. And we are all very cognizant of cost and working to do everything we can to ensure that we're working as efficiently as possible so that we are keeping the taxpayers in mind. With that, I don't want to delay particularly our minority leader, who I'm sure has a lot of other things on his plate today. But Leader Dermody, if you and Mr. Piccola could join us to share some of your insights from the Larsen investigation and impeachment, that would be very helpful. We appreciate you being here this morning. The floor is yours if you want to maybe offer just some introductory remarks kind of about the process and how you came to be a part of it in 1993 and 4. That would be great. Thank you, Mr. Leader.
Well, thank you, Mr. Chairman. Yeah, Jeff and I lost about 1.5 years of our lives in 1994 working on the Larsen case. And I became involved because we were in the majority. I was chairman of the Subcommittee on Courts, and Jeff was the Republican chairman, I believe. Of the whole committee. Yeah. And there's a reason that impeachment occurs every 150 years, because it ought to be rare. It's a very serious case. Obviously, we're nullifying, with impeachment, you're nullifying an election. And it needs to be reserved for the most extreme cases, the most serious cases, and it needs to be necessary to move forward. It was a difficult time, but the investigation that we did and the research that we did made it clear that due process is incredibly important. It has to be preserved. It has to be honored. It has to be a bipartisan effort. It cannot degenerate into a Democratic-Republican issues. It can't be related to elections, and it needs to be rare. Now, I'm happy to answer any questions you have today, but generally in opening, you get to move cautiously, in my view, And I think some of the changes that have happened are of some concern to me also. I can talk to you about that. I think the fact that the general isn't running should enter in any decisions that the subcommittee should make.
Thank you.
Thank you, Mr. Chairman, members of the committee. I discovered that you know when you're getting old when you're asked to come and testify about history, and that's exactly what Frank and I are here to do today. I do appreciate the opportunity because it really was being part of history. In fact, I remember at the time thinking when I was an attorney, politician, and a student of history, you thought you died and went to heaven when you were involved in that impeachment process, because it's something that is very rare in the political, legal, and constitutional process. As has been mentioned a number of times, impeachment is very rare, but keep in mind it is a very unique power of the House of Representatives solely. It's a power that you have and that you need to guard jealously. It is infrequently used. But it is asked for frequently. I remember when I was chairman of the committee, we got petitions for impeachment on a regular basis from private citizens and others throughout the Commonwealth. As has also been said, it was last used before Larson in the 19th century, successfully used. And the question might be, well, why has it been so infrequently used since that time? Number one, obviously, it is cumbersome. It is a very difficult process to engage in. Secondly, I think since the early 19th century, we have expanded and refined quite significantly our criminal justice system, which addresses a lot of what I believe was intended by the impeachment process. The criminal justice system, and I don't have to tell this committee that, is quite large, detailed, and very refined. In addition, we have something in place today, in fact, we've had it for quite a number of years, a judicial discipline system, which doesn't really apply to the case you're looking at, but it did when we were looking at a justice of the Supreme Court. That system usually takes care of the problems that might be the obvious use for an impeachment proceeding. Now, both of these, the criminal justice system and the judicial discipline system, were in operation during the Larson situation and investigation. In fact, before we culminated our process, Justice Larson was in fact removed from the Supreme Court and was convicted by the Court of Common Pleas for various and sundry offenses. And I didn't do the research to recall what all of those were. And we faced some of the same questions at that time, and I think Frank would agree with this, that well, why are you proceeding? He's already removed. He has been convicted of a crime. And the answer at that time was, well, criminal justice is criminal justice, and they have rights of appeal. So we really don't know what the end result of that whole process will be. And the other reason is contained in our Constitution, and that was Article 6, Section 6, which lays out the punishment for impeachment, one of which is removal from office, but the other, and it's something to keep in mind and put whatever emphasis you want on it, disqualification to hold any office of trust or profit under this Commonwealth. And that's presumably for all time. So that is something that is very unique to the impeachment process, and I really think that as members of the House of Representatives, this power being unique to the House, you need to take that into consideration. I have only 3 points of advice that I would give to the committee. One has already been mentioned several times, and that is bipartisanship. You simply cannot go into this process without an atmosphere of bipartisanship, that both sides of the aisle have to want to engage in the process. We had that in 1993 and 94, and quite frankly, if you are not going to engage in that kind of a process, then you're faced with a very difficult time in the Senate, which requires a 2/3 majority to convict. And last time I looked, nobody has that kind of majority in the Senate. The second thing that I would advise is, if you decide to go down this road, if you get into this process, that you engage outside counsel. Frank and I engaged very distinguished counsel, Clayton Undercuffler of the law firm of Saul Ewing, and John Moses, a practitioner from, I believe, Lackawanna County.
Wilkes-Barre, Luzerne County.
Luzerne County.
Luzerne County.
Luzerne County. And we worked very closely with both of those gentlemen. Now, this is not to denigrate your staff. You have great staff. We had great staff. But they are just not capable of engaging in the kind of preparation that you have to engage in to try an impeachment case, not only before the grand jury or the House, but also before the Senate. I mean, there's untold numbers of hours of research, reading documents, interviewing witnesses. We interviewed at least 3 Supreme Court justices, I think, plus a number of other witnesses, and the documents were voluminous. So outside counsel, bipartisanship, and finally, again, if you go down this road, examine your jury. You don't have the right to engage in jury selection. Your jury is going to be handed to you. I served in that jury for a number of years. Read in detail, and have your staff read in detail the proceedings before the Senate in the Larson case. I think that will be revealing in terms of how you would approach this particular case. Senator Greenleaf was chairman of the Judiciary Committee back in those days, and he's still the chairman of the Judiciary Committee. So I would presume that he will be presiding over the Senate trial. So read those transcripts carefully. They will tell you a lot about how the jury might be thinking on various points that you may take before them. But again, it's a long and arduous process, and if you decide to go down this path, I wish you the best. Thank you.
Mr. Chairman, just a comment on the Larson trial.
Please.
His criminal trial was in Allegheny County, and I had the opportunity, because of scheduling, to attend most of it. He was charged, I believe, as I recall, with having his staff get some prescription drugs. He was being treated for depression and a few other things I think he wanted to keep secret. Our investigation had begun prior to that, and we continued afterwards. But as Jeff has mentioned, we moved forward. But I do believe he had several years left on his term. It was a judge, which is a big distinction here. And we wouldn't resign. And I thought, watching that case, I was surprised he was convicted, and it was still on appeal. So we continued to move forward with the impeachment on that basis.
Along those lines, well, before we do that, let me just recognize Representatives Keller, Joswiak, and Regan have joined us. Along those lines, if I can just jump in with a question here. Sure. Could you comment a little bit about the decision-making to continue moving down? I read the journal entries from the House back in 1994, and I think there was talk, and it may have been you, Leader Dermody, that made the comment, I don't recall, but about the separate tracks of impeachment versus the criminal justice system. Could you maybe expand upon that a little bit in terms of your decision-making to, and how you thought through that process about how the criminal justice charges may or may not implicate the impeachment proceedings?
Well, they were obviously part of, he was convicted of a crime, and it also had anything to do with his job performance, really. And that was also an issue. And we had started the investigation prior to that. He had, I believe he had 8 years left on his retention, I think, in the court. So, and he refused to resign. And I do believe, my thoughts at the time were, I don't know whether I even talked to Jeff about it, probably we all talked about it. Had he resigned, going through this process, it wasn't worth it. I mean, it is a cumbersome, difficult process and a costly process, and it should be. It ought to be. Sure. But then when he would not resign, I think we had no choice but to move forward. If the courts come back and the conviction's overturned or he's back in trial again, and then we abandon the process, then we have to start over again, probably, because there were some other serious issues there that we had to deal with that were part of the, I think there were 7 articles of impeachment. And they were serious issues. So we made sure those serious issues were heard, and we ought to move forward.
Do you have anything to add there, Jeff?
Yeah, I believe if he had resigned early in the process, it probably would have evaporated. That's my guess, but anything's possible. But the allegations initially were not criminally related. They came out later as a result of the courts and the district attorney's investigation of some of the allegations that Justice Larson made that turned out to be false. And so we we continued our investigation and ultimately got to where we were before the Senate.
And I think, if I remember correctly, I know you mentioned 7 articles of impeachment. I think the Senate ended up finding on one of them, and it was not the one that was based on the criminal conduct, if I'm not mistaken.
That's correct.
It was totally separate conduct.
It was based on what was most related to his job. That is, he favored, clearly, was favoring a litigant involved in a case before the Supreme Court.
Sure.
And that's the one they convicted him on. I was a little upset at the time, but in hindsight, that was the right thing to do. We were living that for a year and a half.
I'm sure.
The Senate believes that too.
Yeah, right. Well, the Senate always believes that.
Could you expand maybe a little bit on just the process that you employed? How did you conduct your investigation? What role did the various members of the committee play? What role did you play? I think you mentioned outside counsel. What role did they play? And how did you move forward?
We worked closely with outside counsel and the members of the subcommittee, and we traveled the state interviewing witnesses all across the state. As Jeff has mentioned, I think it was 3 or 4 Supreme Court justices, several common police court judges, and other witnesses. There were, I forget how many, but there were several witnesses. We interviewed first, and then we would have, if there was worthwhile testimony, we would have a committee hearing, and they'd be sworn in, and we took testimony and built a record. And had that record in place when we presented the articles of impeachment to the House of Representatives.
Yeah, ironically, the Republicans were in the minority, but Frank and his folks delegated a lot of the investigation to us. We had hired, as I said before, Clayton Undercuffler as our counsel, but he brought with him all of the resources of a very large Philadelphia-based law firm. John Moses had a smaller firm.
John Moses.
I think it was just John Moses that I recall. So a lot of the investigative tasks were delegated to us. Now Frank would accompany us, or other members of the committee of management.
I attended most of them. I think all of them. Really.
Probably you did, all, yeah. But we delegated.
We split the
work. We
work.
delegated back and forth what the various responsibilities were, the various interviews. And shared the responsibilities. I can probably count on one hand when even a hint of partisanship, and it's a kind of a funny story, so I won't go into it here. But it raised itself, but it really was inconsequential in the great scheme of things.
So you would conduct sort of an off-the-record proffer session with the witnesses, and then make a determination about whether or not you needed a full-blown hearing. On the record, under oath.
Correct. And we did not just we interviewed the witnesses. We didn't rely on prior hearings or in the criminal trial testimony. We obviously reviewed it, but we went and got the witnesses and interviewed them ourselves. It's the House's investigation. It's your political process.
I guess that's what I wanted to touch on a little bit, because you had, in that case, I think you mentioned you started the investigation, and then the criminal conduct.
That came after we started our investigation. There was a couple of years of things flying around with Justice Larson and the court, and it got very messy, and there were a lot of issues out there at the time.
So you didn't have the benefit of any of that criminal investigation when you started out your investigation. You were starting with a blank slate, in essence.
That came later.
Any other members of the committee have questions?
Thank you, Chairman, and thank you very much. This is. As someone who's interested in the historical aspect of the job, it's definitely neat to talk to you guys. You both mentioned outside counsel. That's definitely something that I think we are strongly considering. You mentioned having your own outside counsel. So one question, if you thought that was a necessary or useful tool to have two separate counsel, and also if you could address, if you recall, what the cost of the 94 process having two counsel, realizing it was 22 years ago. And the third thing, I'll try to package it all together, is you had mentioned 93, 94, was it all within one legislative session, the beginning, the commencement of the process to the hearing in the Senate and when the Senate decided?
It was, as I recall, it was one session, but it took about the whole session.
Yeah, I think
we didn't finish up till October.
There was some. I think there was some discussion because, as Frank said, the controversy over Justice Larson had been swirling for a couple of years, and there were allegations being thrown back and forth between members of the court about you did this or you did that. But I think we settled in on the process right after the beginning of the session in January of 1993, and with the various resolutions to investigate. And early on, we decided to get your question. I don't know what we spent, but I'm sure it was a lot of money.
We looked it up. It was about 1.5 million.
Is that what it was? So, I mean, that's
$94.
low. That was low. I would have thought more, but at any rate,
Legal fees and all.
it is definitely a commitment of resources, and you know, I can understand it, watching you guys from the outside, that money is a big issue here in Harrisburg right now. But again, this is a unique power to the House of Representatives, so you have to weigh those judgments as you decide whether you're going to go down this path or not.
And with Council Representative Briggs, we had to, and it worked out well. I mean, we worked closely together, and it was bipartisan all the way. But I do believe that if you go that route, that if you can agree on an outside counsel, you can get by. One counsel would work if you were able to get that done. The way we worked it, it worked out fine, though.
I mean, if you could find somebody that meets that the unique criteria for both sides of the aisle, I don't think that's a problem. But we were old back in those days, and it stuck in our ways. So everything was done in two different caucuses. So maybe you guys are a little more modern than we are.
I'm not going to comment on that. But Chairman Stevens and I are committed to doing this, I think, together. I know together. And I'm not going to ask what the specific instance was, but the number of times on one hand that you counted that partisanness came in or a difficulty, I mean, that's something that I think both of us have talked about as you know, honesty and communication is something that we have to strive. So having separate counsel, I could see definitely benefits to that, but I could see it being a little bit setting yourselves up for already having a little bit of a adversarial relationship.
It was kind of a humorous story, and I'll share it with you off the record, but it was...
I don't remember.
I'll share it with you too, Frank.
Maybe in the leader's office this afternoon.
But it really resolved itself. I mean, it was resolved fine, but in the ultimate scheme of things, it didn't even matter because the issue was resolved without any action on our part.
I think I just do want the record to show that the committee has our first I don't remember, I don't recall, which, you know, as a prosecutor, I remember interviewing folks and getting a lot of that. Representative Nesbitt, I think you had a question.
Going back, Leader Dermody, you had said you were surprised that he was convicted in the criminal case?
After attending the trial, yes.
Okay, but you still felt it was important to go forward with the impeachment, even though the criminal case
The criminal case was not a big factor in the ultimate decision to move ahead with impeachment of Justice Larson.
And that was based in part because of actions that actually included things in his job?
That's correct.
Okay. The other thing that I was curious about, is, especially with you being a former prosecutor, how did you balance the investigation of the impeachment versus the criminal in terms of making sure you didn't interfere in any way with witnesses giving statements or conflicting statements and transcripts and those kind of things that would be difficult? Is there any advice on how we make sure that we don't tread into the criminal or make their job more difficult?
I think you need to be very careful, and that's the part of the problem here. That trial was over before we really got to the meat of the whole investigation. It was over earlier so that we could move forward. And we could talk to the people who were involved with the criminal case because it was over, it was done for the most part. Now you're facing the issue that the criminal cases pending here aren't until August, and you've got to be careful that I'm assuming the DA doesn't want the Judiciary Committee snooping around until they're done. I mean, you're not going to be able to go after, I don't think, and interview witnesses, those types of things until those cases are completed.
Well, I think that's one of the things that we have to be careful of, but I think we're also exploring. So that was the end of questions. Thank you, Mr. Chairman.
I had a sort of a follow-up to that. In terms of the balance of the confidential, sort of off-the-record proffer communications versus the public hearings, can you share a little bit about how that played out and why that approach you think was helpful as you conducted your investigation?
My recollection is that most of that was conducted by our outside counsel working in tandem. I think Frank and I attended some of the more significant interviews, but a lot of it and a lot of the review of the documents was handled by counsel. Frank had the benefit of being a former prosecutor. I am not even a trial lawyer, let alone a prosecutor. So even though I am an attorney, and I've done a few trials, but and that's one of the reasons you have to, if you're going to get outside counsel, you better get somebody who has some trial experience, because they got to prepare for the trial. I mean, that's basically what you're talking about. I can remember when we made the decision to hire outside counsel, the sigh of relief that came from our staff at the time. They were just afraid they were going to have to do it. And you and they have a whole lot of other responsibilities outside of that impeachment process. So you have to continue doing those. You just can't devote 100% of your time to the impeachment. They can't devote 100% of their time to it. So experienced outside counsel is essential, and they will, if you get the right people, they will do a lot of that trial preparation work.
You know, we had to make some decisions of whether or not the various witnesses, whether testimony was relevant, whether we thought it was substantial enough to move forward with, and that's why those interviews were done prior to a hearing.
In terms of the criteria for counsel, I think you both touched on a couple different pieces. What would you recommend in terms of, you know, what experiences, what biographical background should we look for?
Jeff is right. You need somebody who has courtroom experience. It's a trial, and you've got to prepare witnesses. You've got to get witnesses ready to. You've done that if you've been in the DA's office and you've gotten ready to go to trial. You're preparing for trial. You've got to make sure you have a case, and then you've got to make sure you can put that case together. And you've got witnesses that are prepared to testify. So you need somebody who has courtroom experience for sure.
And I think maybe a little bit broader courtroom experience than just simply criminal justice
Absolutely,
work.
yeah,
Because,
I agree with that.
Because while that's going to be important, I think you have to have a little bit more broad outlook, because this is impeachment. This is not strictly speaking, a criminal trial.
It's not a criminal trial. You run it. There's no rules of evidence other than what you decide, you determine fairness is. The rules of evidence are what you make it.
All right. Any other questions from any members of the committee? Representative Bizzaro?
Thank you. We've touched on procedure, we've touched on cost, but I want to go back to time. Now, do you think, given the dynamics of this case ahead of us, do you think that we will get this properly solved in 8 months? We're looking at 8 months till the current Attorney General's term expires. She's not running for re-election. Do you think it is possible to get this process done within the 8-month timeline that we have?
I think it's difficult, and I do have some doubts as to whether it's necessary. And I think that's crucial. I think it's important before you proceed on an impeachment of any type that it's absolutely necessary. And if you have a situation where you have an election coming up and you don't want it to appear that there's try to get any leg up in an election, but we have significant elections coming up, including for Attorney General, and you have an Attorney General who's leaving and the criminal cases are still pending. I think it's going to be difficult to comply with the rules and what you would want to have with regards to due process in an impeachment proceeding. To get that done in that period of time is most difficult.
Thank you.
I think it's possible. It'd be difficult, but it would be possible. I think the issues, and again, I don't know any inside information except what I read in the public media. The issues are a little bit less complex in the case facing you than, I mean, we had allegations from criminal justice on through improper influencing of a judge through contact with litigants and allegations of attempted hit and run and
Yes.
all kinds of allegations that, I mean, they were very, very wide and dispersed in the Larson case. So I think it's possible, but it's going to be very difficult. You better get cracking.
So we start now then, right?
Well, it seems like you have.
Representative Briggs, and then we'll get to Representative Saccone.
Senator, you had mentioned the complexity of the Larson situation. I mean, one of the challenges that we have, and I know we're not talking about specific things, is you don't know what you're going to uncover. You know, I don't know if you knew everything you were going to find
not.
in 93 and 94. What was it in 93, 94 as you, as the complexity developed and the Senate charge, you know, found one article of impeachment as worthy? Do you think, looking back on it, you should have continued to develop the whole case? I don't know if I'm articulating it right. Did it need to be as complex, or do you think if you had just found the one or two or three things that were slam dunks that, you know, you could have ended the investigation and filed?
Well, in hindsight, that's probably possible, but I don't think looking at from the perspective we were in early '93 that. I mean, as we got into it, we started to uncover things like peeling an onion. I mean, you had different layers. We uncovered some stuff that actually never even came out in the public record because, but just stuff that was, we had to make judgments on whether to put it in or not put it into the proceedings. So it turned out to be extremely, and as you know, the court, especially back in those days, was a very secretive body. They don't publish their deliberations and their communications with each other. I guess they do now, but getting into that was a difficult process. I don't know what you're going to be faced with here. I haven't even thought that through yet.
I don't know if you had any.
Well, no, I agree. I think we had to go through it all. I mean, there was some, as Jeff has mentioned, we both mentioned, there was a lot swirling around with just Larson for a couple of years, and I think for the good of the court, we needed to make sure we investigated all those areas, and we would have made a mistake if we hadn't. So it just takes time.
While we had the judicial discipline process in place, there was a lot of questions whether the court would even enforce it against one of their own. And so we felt the impeachment process was the safety valve there. So that's another reason I think we continue to move forward.
Representative Saccone.
Thank you, Mr. Chairman. And so I know you didn't face this particular question that I'm about to ask because in the Larson case he had 8 years left, and you wanted to make sure that this was dealt with, but I keep hearing that because there's only a few months left and the term's about to expire, that might be one consideration as to why we would not proceed. And I'm interested in your comments on whether, as the impeachment process, as a matter of principle, if we have found issues that are worthy of impeachment, whether as a matter of principle we shouldn't proceed no matter what the time is, because it is a matter of principle. If there are issues that are worthy of impeachment, we shouldn't just ignore them and say, well, the time's running out, let's just let it go. That because if there are issues that we've identified that are worthy of impeachment, that we should proceed on principle. Do you have any comments on that?
Well, that's a judgment you all are going to have to make, and I would base it on two constitutional provisions. Number one, that impeachment is unique to the House of Representatives, and if you give it up, in this particular case, you've given it up for all time. Secondly, the punishment for impeachment is not just removal from office. It is a preclusion from serving in any position, appointed or elected, position of trust or profit under the Commonwealth. I think those are the constitutional words. So you have to make that decision, too, whether the person upon whom the impeachment is focused, whether you feel it necessary as a protection to the people of the Commonwealth to prevent that person from ever serving in public office and public, either appointed or elected, again. And that's a judgment you all have to make. And there's nothing to say it couldn't spill over into another term. I mean, there's nothing that precludes any of that.
Thank you. Appreciate that.
Well, I mean, I think you have to be careful. You have criminal trials that haven't started yet. And after November, if the Attorney General doesn't run, he'll no longer be a civil officer. So there's not going to be any carryover to another term. If you're not a civil officer, you can't be impeached. So, I mean, it's a difficult process, and it has to be done correctly. As I've stated, it's got to be fair, it has to be done right, and it needs to be necessary, I think, to move forward. That's a determination you have to make as a committee, a subcommittee, and a judiciary committee, and maybe the whole House. We'll see. We did not have the benefit of the criminal investigation when we started our process. It became available later. But you have to do your own independent investigation because it's an impeachment. And it's rare. It ought to be rare. But when you do it, it needs to be done right.
Along those lines, I mean, I think, from what I understand, you guys were the trailblazers in terms of creating the procedure that Representative Briggs and I are hoping to follow. I mean, the Constitution provides very little guidance in terms of the actual procedure. And just correct me if I'm wrong, but the procedure you employed was to conduct your investigation first as a subcommittee, and then make recommendations to the House Judiciary Committee, who would then those articles of impeachment, those recommendations would go before the full House of Representatives, and then the final step is the trial over in the Senate. So this is just the very beginning part of what may or may not, depending, I mean, each step of the way, you may reach a conclusion that it doesn't make sense or it isn't appropriate to move forward for whatever reason. And I guess it's a long-winded question, but my ultimate question is that cost-benefit analysis that you seem to be referring to, I mean, that's appropriate at every step along the way, am I right? In other words, until you investigate to understand what the benefit might be or what the issues may be or may not be, it's hard to draw a conclusion about whether it's worthwhile proceeding. Do you understand?
I agree. I mean, we had to go back. We looked at the 1,700 impeachments, and we had better records there, I think, than the early 1,800. And went back to read the Federalist Papers, because Hamilton wrote about impeachment. We started. Then we went to Washington, because obviously we met with the staff of the Judiciary Committee in the House, because they've done several. And we try to replicate what was done earlier in Pennsylvania, and worked with the Judiciary Committee in Washington and followed some of their steps about how we proceed. Had the subcommittee do the work, a very thorough investigation. I think you had a report that we sent around a filing in the court, the case on researching impeachment, and you read where the staff of the House Judiciary Committee said that the subcommittee on court should do this. It needs to be thorough, and it needs to be their own investigation. You can't rely on outside folks. You can rely on them for part of it, but you have to do your own investigation, and you should.
Yeah, I think you have one advantage that we didn't have, and Frank's kind of summarized it, and that is we didn't have a template of any sort. We were making things up as we went. At least you guys have, and gals have, the benefit of our procedure that we set up, and I think Frank and I would agree it was a good procedure. I think but it took time to develop. I mean, that wasn't something that we started out of the box with. That was something that developed the early part of '93 before we got actually into the drafting of resolutions and articles of impeachment. I mean, that setting up that template was a time-consuming process. So you could probably discount our time a little bit. I mean, again, I'd have to go back and look at the whole record, but you could discount the time it took us a little bit because hopefully you would use our template.
Well, I know that from my personal perspective, we're hoping to, and we're certainly trying to, and I think Representative Briggs shares that concern. It seemed to work out well in terms of getting to the truth, which is our goal, and there's no need to reinvent the wheel in that regard. If what you did got to the truth, then we hope to achieve the same result following the same procedure. Any other questions? Yes, Representative Tuhill.
Thank you. This could be for either of you, Leader Dermody or Senator Pecola. For those of us that aren't familiar with the Larson case, do you think that it was the gravity of the offenses that were coming up, or the type of misconduct? What was it about that case that made you decide to proceed with the impeachment?
It became clear that, it's in my view, I think Jeff feels the same way about that he was involved with litigants before the court, and they got favors, and they got help that they should not have received from a justice of the Supreme Court. That goes to the heart of fairness and our judicial system, so that we had to address that.
Yeah, I remember coming to a conclusion that something had to be done when there were conflicting allegations coming out of the mouths. I mean, these were quotations coming out of the mouths of Supreme Court justices, and I commented to somebody at the time, well, somebody's lying. And when that happened, it was apparent to me that the whole credibility of our judiciary was being undercut, and that obviously impeachment is one of the remedies, potential remedies for addressing that issue if it can't be addressed by the court itself. And it was well, you had to almost be living at the time to understand how remarkable it was that this was happening with our court.
And that we had to go through this. I mean, I think we said earlier, had he resigned, this we wouldn't have to go through all of this, but it was all, we had no choice. And he was a Supreme Court justice with 8 years left.
Okay, I guess that kind of helps because I'm looking for some sort of standard or benchmark where you would say it rises to this level where you would begin the impeachment process. And then I don't know if you would agree that when you look at, and we're not in the criminal context, but when you look at criminal cases and prosecutorial discretion, that you have, sometimes you have a prosecutor that goes after a case and it's not necessarily the outcome, but it's more of what you were looking at where you're searching for justice, you're searching for truth. There were, I don't know if in this case that you would look at it and think, I mean, in the Larson case, would you look at it and think that it was something that you had to do to pursue and it wasn't necessarily going to matter what the outcome would be at the end of the day, that the person wasn't in office, or, I mean, he could have resigned at any point during the time that you were doing your investigation, your impeachment?
I think, well, let me put it this way. There's the people of Pennsylvania and the people of the United States have a very healthy skepticism about elected officials, I think. But with House members, senators, governors, they get to voice their opinion on those folks, us, every 2 or 4 years. There is a, I think, a less than healthy skepticism about our judicial system and our criminal justice system. And both the case you're faced with today and the one we were faced with reflect on a possible undermining of, and it certainly wasn't undermining in our situation, possible undermining of the credibility in the minds of the public of the fairness and objectivity of that judicial system, the justice system, if you will, criminal and or civil. So I think that's where I think, at least from my perspective, that's what raised my level of concern that we needed to go beyond just what we would typically do and you know, just count on elections to solve the problem, because certainly with our case, we couldn't count on elections.
I mean, the voters only get a chance every 10 years, and it's a retention vote.
Okay.
I mean, these other elected offices, they have a chance to fix things every 2 or 4 years. The voters do.
All right, any other questions? I do want to acknowledge Representative Mullery, who's joined us. Thank you. And gentlemen, thank you so much for taking the time to join us today and share some insights and suggestions and thoughts. We appreciate it. We hope that you'll be available for us as needed through this process if necessary.
I'll be around.
You have my number.
Thank you very much.
Thanks.
Next, we'd like to have Professor Stephen Ross. Good morning, Professor. Thank you so much for joining us. We appreciate you taking time from your schedule to share some of the legal perspectives and insights as it relates to impeachment here in Pennsylvania and some of the things that we should be mindful of as we move down this journey.
Thank you, Chairman Stevens. If any of my first-year law students whose class has been rescheduled till this afternoon are any of your constituents, I'll be sure to.
Well, that's a long commute.
I'm happy to be here and happy to provide whatever resources or expertise I can to your venture. Those of you who graduated from law school no doubt remember, or at least when prompted, the famous line from Chief Justice John Marshall's decision in Marbury versus Madison: "It is emphatically the province of the Judicial Department to say what the law is." That sentence, which is oft quoted, is often taken out of context. With regard to impeachment, Chief Justice Marshall made it clear, even in Marbury versus Madison, that that quote only applied to cases properly before the courts. With regard to impeachment, which is not a non-justiciable issue, it is emphatically the legislature's job to say what the law is. I borrow from both the decision and scholarship of Chief Justice William Rehnquist in my testimony in suggesting that the key precedent in the federal level for impeachment was the failure of 2/3 of the Senate to impeach Supreme Court Justice Samuel Chase in 1805. Justice Chase was a Federalist judge. At the time, the Senate was overwhelmingly Jeffersonian, 22-9 in the Senate at the time. And the Senate could have impeached him for simply making bad decisions as a Federalist judge. Indeed, that seems to be what President Jefferson in retirement in Monticello actually thought should happen. But they didn't. And if they did, as Chief Justice Rehnquist observes, we would have a very different constitutional structure in our country because we would no longer have an independent judiciary. Justice Chase could have been impeached for severe ethical issues. Among the things that Justice Chase did was, while sitting as a Supreme Court justice, actively campaigned for John Adams over Thomas Jefferson in the 1800 election, and presided while riding circuit over a criminal trial of a Jeffersonian activist whose prosecution he had initiated by writing the U.S. attorney, conduct that probably would not be tolerated today. But the idea of impeaching a judge for severe ethical issues is open to political manipulation. The vote has been understood as a precedent, just like Brown versus Board of Education or Marbury versus Madison, that the constitutional term under the U.S. Constitution of good behavior means that judges have life tenure absent a conviction for criminal offenses or the commission of serious equivalent acts. Another precedent was set in 1974 by the United States House Judiciary Committee in its impeachment proceedings against President Richard Nixon. He was impeached by the House. Articles of impeachment were voted out by the House Judiciary Committee for various quasi-criminal conduct relating to the Watergate affair. There were two other articles of impeachment which the House Judiciary Committee voted not to recommend impeachment on. One was President Nixon's abuse of the Internal Revenue Service to target his political enemies. The second was his deliberate lying to Congress about the war in Cambodia, what was called the secret war, although it probably wasn't very secret to people in Cambodia. What these precedents reveal is something that in the British Commonwealth is called a constitutional convention. That is a rule that is accepted as constitutional law, but it is not judicially enforced or decreed by the Supreme Court. As I tell my class when I teach this concept, as a matter of legally as opposed to constitutionally, I could turn on my phone at the end of this hearing and see a call from Buckingham Palace where Her Majesty has decided to sack David Cameron and appoint me Prime Minister. That is within her powers, but it would be seen as unconstitutional for her to do so based on a convention. To give a more American tune to the concept of constitutional convention, it is the pretty well-established constitutional convention, both in Washington and in Harrisburg, that the Senate will confirm qualified nominees of the executive of another party. Now, that is not the way things have to work. That is not the way it works in France. In France, if the legislature has a majority that is the party opposite the president and the leader of the legislative majority works out a deal, they call it cohabitation, where each side gets their share. That is not our convention, our tradition here, either in Washington or Harrisburg. A leading British scholar has set forth 3 criteria for determining what is a constitutional convention. One is to examine what are the precedents, what has happened in the past. Second, whether actors believe they are bound by the rule. Is this just a deal between Chairman Stevens and Chairman Briggs so next time it comes up, it could be another deal, or is this a principle that Chairman Stevens and Chairman Briggs believe they are bound to? And then finally, is there a good reason for the rule? What does this mean? What this means is there's a variety of options that this committee could take in determining what constitutes misbehavior under the Constitution worthy of impeachment. And I just want to sketch out some. Leader Dermody has already indicated his views, which would seem to reject the first two, but that's up to the committee to work on. One option is misbehavior is a purely political decision. That is, impeachment for misbehavior of an executive branch officer is any grounds that you can get a majority of the Senate, majority of the House, and 2/3 of the Senate to pass. There's no principle involved. It's just politics. Option B is a parliamentary system of no confidence. If the legislature lacks confidence in the ability of the executive branch officer to carry out their duties, then they can be impeached. A third example, which would have been illustrated by President Nixon's treatment with the IRS, is gross abuse of power. It is not something that is necessarily proven criminally liable, but it is something that is considered to be so abusive that we do not want that person to be holding office. And then option D would be serious criminal conduct or misconduct of a similar nature. There are also procedures that you could adopt as precedent. One idea just occurred to me, I confess, in light of the professions of desire for bipartisanship, would be to adopt a version of the Good Friday Agreement that Senator George Mitchell brokered in Northern Ireland, which is to say that on something this important where we claim we need bipartisanship, we will not move in advance, the committee could decide, we will not move forward unless we get at least some fixed percentage, 35 or 40% of both parties to support it. And if that doesn't happen, then we're just not going to move forward. So that's another option for the committee to decide. If the committee decides to exercise, and I thought Representative Toole's phrase of prosecutorial discretion was apt, it's prosecutorial discretion not to move forward. You have the discretion to do that for any reason, and it really doesn't set a precedent. It's purely discretionary, in the same way that those of you who are former prosecutors, you need to decide because of 9 different circumstances you're not going to prosecute somebody for a crime. That says nothing about the crime, the next time around, or anything else. And so you could decide to exercise your prosecutorial discretion because it's going to take too long, time's running out, we're in a budget crisis, whatever reason you want, that is within your discretion to do. However, if you decide not to exercise a pure question of prosecutorial discretion, I would strongly urge you to regard your decision as precedential, like courts. And the House report, your report to the committee, your committee report to the full House, should carefully explain your rationale if you are assuming that you're going to pursue anything other than a purely political option, to clearly state your own views on what is the appropriate standard for impeachment, and if you recommend articles of impeachment, why you think the particular officer ought to be impeached, and if you recommend not proceeding with impeachment, why you feel that the standard you have established was not met. That will not only serve your process and certainly Chairman Stevens and Chairman Briggs' goal of a bipartisanship, but also serve another template for future legislatures to consider. And I would suggest, because of the rarity of the act, not only in the Commonwealth of Pennsylvania, but throughout the nation. I appreciate your attention and look forward to answering any questions I have now and serving as a resource to you or your staffs moving forward.
Anyone, any members of the committee have any questions? Chairman Briggs?
Thank you very much, Professor. So it kind of came up with Senator Piccola and Leader Dermody about the removal, but then also the prohibition from further office. If our timeline gets us to a point, if we proceed and take it all the way to the end, to a Senate hearing, and it's past the point of the current office holder's term in office, in January, February, there's a hearing. Could you impeach at that point?
You've gone beyond my, one of the things I've always prided myself is on providing my expertise when I have expertise and not providing my expertise when I don't. You've asked me a particular question about the particular nature of the Pennsylvania Constitution, which provides for the impeachment of civil officers. And that is something, I can frame the issue for you. It's like issue spotting in a law school exam, but I have no idea, I do not know what the answer is to that question.
Another reason why good outside counsel would be helpful during this process. If and this may be the same sort of question, if the House majority decides to send a matter to the Senate, does the Senate, are they required to have a hearing? A trial?
Okay, well, when we use the word required here, we normally in law think about somebody is required to do something if a judge will tell them that they have to do it if they don't. So in that sense, the Senate is not required to do anything. In fact, there was the U.S. Supreme Court, again, an opinion by Chief Justice Rehnquist made this clear. They impeached a federal judge for criminal activity, and the Senate did not take the whole evidence. The full Senate did not actually try the case. They designated a committee to try the case. They then presented the entire transcript to the full Senate, and then they gave the managers and the defendants' counsel an opportunity to argue the case before the entire Senate. And the issue that was before the Supreme Court was whether that was a breach of the U.S. Senate's constitutional responsibility to try all impeachments. And the Supreme Court said the U.S. Senate has the sole power to try, which means they have the sole power to determine what they should do. So I would say that in the sense that we normally think of it, there is no outside remedy if the Senate were to choose not to do this. But they're making the constitutional law. I would say that in making the constitutional law, that's up to the Senate to decide to do, and then they are setting the law. Just like a judge in a criminal case, I would presume that the Senate would have the option to for example, say I would assume they'd have to vote on this, but we are not going to proceed with the articles of impeachment because it would not be in the interests of justice. Just as my understanding is that a court of common pleas judge has the authority if a prosecutor has properly charged someone without before they even tried the case to decide for whatever, if some compelling reason, that they're just going to dismiss the case in the interests of justice. And that would be an option for the Senate. Consistent with my testimony here, I would hope that the proponents would set forth very clearly what the standards are and why they are doing it. And it would be because it would be setting a precedent for the future. But in terms of what their options are, that is something the Senate has to decide for itself.
And one final question. I mean, obviously, this is a rare instance that impeachment's pursued. Do you have through the federal court process or anything, do you have a sense how many impeachments there have been that have gone all? You mentioned a couple of them. I mean, it's public. In fact, you could probably look it up on Wikipedia. It's so easily available, but it is a rare number of judges who have been impeached, and almost always following a criminal conviction, and where the judge refuses to step down from the bench even though they've been convicted. There is one famous case, Judge Alcee Hastings, who was criminally convicted, would not step down, was impeached, and then ended up running and winning a seat in the House of Representatives. So, because the U.S. Congress does not have the provision of disqualification for office. So, but it is certainly rare in the sort of same nature as the rare event
here. The reality is that most people in this situation want to contest it criminally, and if they're convicted, they resign. I mean, that's just the historical reality of what happens. And once in the federal system, once the Constitutional Convention was created that we only do impeach for criminal or quasi-criminal action, then that's why I think it is so rare.
Can I just follow up on that? And correct me if I'm wrong, because you're the professional here. The Pennsylvania Constitution is different from the U.S. Constitution in that regard, though, if I'm not mistaken, as it relates to non-judicial officials. In other words, misbehavior in office within our Constitution is very clearly not limited to strictly criminal conduct. Is that right?
Well, this has come up, certainly this came up in the Chase impeachment because the U.S. Constitution's term is good behavior. And it came up in various impeachments, most directly with President Nixon with regard to the constitutional phrase high crimes and misdemeanors. And it is pretty clearly recognized that the phrase high crime, which had an English origin, did not refer to criminal felonies. It was not just an old antiquated term for felonies. So it's clear that the term is not intended to limit you to criminal offenses. And it is also pretty well accepted that it would be a breach of convention to, for example, I think it is almost certain, if not admitted, that President Obama has violated federal law when he uses the email or a phone to participate in the March Madness betting pool, which he usually does. That is, if you look at the Wire Act, that's actually technically a violation. I would think that most people would regard it as unconstitutional if the House of Representatives impeached President Obama for betting on the NCAA pool, even though it's a misdemeanor and therefore literally in the Constitution. On the other hand, during the Nixon impeachment, I think it was clear, although they decided that the particular offenses should not be used, that non-criminal activity that are grossly abuse power is the sort of thing that is inappropriate. I mean, one of the things I think that is useful. Another thing is you don't have to set precedents when they're not relevant. So as your investigation into the Attorney General's conduct continues, one of the things you might answer is, are the accusations involve conduct where we just want to use the criminal standard? So if in fact, and again, I take no position on the actual issues and I'm just going by what I read, if in fact the sole reason to impeach her is because she engaged in leaking materials from a secret grand jury, and if that's the sole basis that you want to impeach, and we have a criminal law against it, you might decide that the appropriate standard is the criminal standard. On the other hand, if your investigation develops other concerns, it is your prerogative to determine anything. And literally, you could decide, as a matter of constitutional law, that misbehavior means whatever you want it to behave. You could decide, if it turns out that she participated in a March Madness betting pool, and you say that is misbehavior, well, you can do that. You're now setting an incredibly high standard for conduct of all civil officers of the Commonwealth. Next time around, with different political dynamic, every civil officer is now going to be liable for impeachment for the slightest criminal activity. But that's the precedent you've set if, in your judgment, you want to set it. Now, some good reasons for you not to set that precedent. But you are basically setting the precedents in the same way that when the U.S. Supreme Court decides what is the appropriate standards for, under the Equal Protection Clause, for treatment of various groups, they're setting the standard. That's really up to you to set in this case.
Right, so it would be your recommendation that we consider our action or inaction as precedent setting as we move forward.
My recommendation is that you, in your minds, clearly delineate between, am I exercising prosecutorial discretion? You're basically you're sort of the prosecutor and the judge and the Supreme Court judge in this matter. So I think it's important, my recommendation would be to separate in your minds, are we exercising a pragmatic, small p political discretionary decision not to move forward, or not? And if you are not exercising a discretionary decision, sort of, if you do not go down the line of Chairman Petrarca asked a number of questions, and if you answered every one of them in a particular way, you would say, this is discretion. But if you decide not to go the discretionary route, and you decide not to prosecute because your investigation determines that there was no misbehavior, or you decide to pursue it because you believe there was misbehavior, then I do think it's important to set forth exactly why, and I think that will set a precedent for the future. And I would not get that hung up on the words, because I think when we go back to the original intent of the framers, and you can look at the U.S. Constitution, the Commonwealth Constitution, Constitution of some other state where there might be some other precedents, I would be very surprised to find any evidence that in crafting the Pennsylvania Constitution, the drafters decided to use misbehavior as opposed to some other word because they really had a well-defined idea of what was impeachment. And that's sort of why you have this responsibility, and I commend you for having a hearing where you're trying to think about this in a rigorous way.
Thank you. Any questions from members of the committee? All right. Professor, thank you very much. We appreciate you joining us and providing some insights and some food for thought for the committee as we move forward. Thanks to the members of the committee for joining us. We'll be in touch about future meetings and hearings. This hearing is concluded. Thank you.